Okay, I'm here today with Doug Berry with Allen, Allen & Allen, and Doug's going to give us the perspective of how the law interprets negligence. Doug, tell us a little bit about yourself.
Well, just briefly, my name is Doug Berry, as Mr. Craven said. I'm the president of Allen, Allen & Allen, which is a personal injury firm in Central Virginia, mainly based, our first office out of Richmond. We do just personal injury, but from a personal standpoint, I am an ex-FBI agent, an ex-prosecutor for many years, and now I do just personal injury law. So I have a pretty good perspective on criminal and civil law in Virginia, and I do a lot of speaking on immunity and things like that to public servants, and this kind of ties in with that.
All right, Doug. So much today about exertional heat stroke. In fact, from 2003 to 2008, there's been 18 young men that have died on the football fields practicing a game. If we were to talk about tort liability and what is tort liability, and can a person be held responsible for that, whether it's intentional or not?
Okay, well, let me just start by saying I'm a Virginia lawyer. I'm only qualified to interpret Virginia law, both common law and the statutes. And again, I'm only one law, and I'm not on the Virginia Supreme Court, so this is my interpretation. So I cannot interpret any other state's law, although many are similar, and there is no federal law or federal standard on this. Tort law is simply the civil side of hurting someone, whether it be a negligent tort, which is an unintentional tort, or whether it be an intentional tort. It is the civil side, not the criminal side.
So the court could hold somebody responsible for their action or inaction if a person dies of exertional heat stroke.
Under Virginia law, we are a commonwealth. By interpretation of common law and or statute in this state, since we're talking mainly about school systems and coaching and athletic injuries and exertional heat stroke and things like that right now, and death or injury, pretty much if any coach, trainer, whoever, assistant coach, is working with the students, if they're there, and something happens, and what happens to that child, that student, rises only to the level on Virginia law of negligence, that coach, public servant, will probably be immune. It has to rise to a higher standard of gross negligence, which I'm sure we'll go into later, in this state.
So even the interpretation, there is some duty, you would say, to protect against issues that they don't even create. So an example, if it's a hot, humid day, not having water available in this day and time would be considered negligent.
That's a great question because, for instance, I played football in the Virginia High School League, AAA, in the 70s. And you go back to the 50s, 60s, and 70s, even later, traditional theory was no or very little water toughens up kids, salt tablets, a lot of other things that we'll go into later. And if you look at it in those terms now in 2010, that science, that knowledge, in my opinion, has caught up with Virginia law. And I think anyone now, from a pure water standpoint, salt tablet, excessive salt tablet standpoint, would see that if it caused injury or death as a grossly negligent act on those two terms. As you go past that, which I'm sure you'll ask, then I have to reinterpret. And on the same vein, I'm talking civil law. There's the criminal side of that. Since those facts have caught up with Virginia law, or Virginia law has caught up with those facts and that hard science, then there's the criminal prosecution side. I think a lot of prosecutors would see that as gross negligence and potentially prosecute someone if there was an injury or a death.
So the courts, if me listening to you right now, the courts are interested in the facts, the science, versus what maybe would be a tradition. Well, I coach football that way because it's the way it was coached to me. But if we know there's certain reasons why water has to be plentiful, why there has to be certain rest periods, why the body has to be acclimated, why the young man shouldn't be out there at practice if he suffered from a heat illness 2 days before. If these standards of care or written to be abided by, then here we go again. The courts are more, in the instance of a young man dying, are more interested in the facts than what the tradition of football is.
Courts in Virginia are not interested in empathy of what used to be. They're not interested in tradition. They're interested in interpreting law. The courts of record in the state are the circuit courts, whether that be on the civil side or the criminal side. Every different judge may interpret the law differently, but once the Virginia Supreme Court rules, then that's hard law, and there's really no room to reinterpret that. And so once that happens, as I said in the past, for instance, I don't think there's anyone who would disagree that on the civil side now, there is no room for interpretation that lack of water, dehydration that causes death would probably rise to the level of gross negligence on the civil side and gross negligence on the criminal side. Beyond that, we'll talk about that in a bit, I'm sure.
So here we go again. It was a lawsuit to cause change. It wasn't from the nature of the information that was available. It was basically a lawsuit that brought people's attention. We've got to change, and we have to change immediately.
It's a great question. I just want to change it just a little bit. You say people like me. I'm one lawyer of many that practice civil law now. Again, I used to be a prosecutor. It's not just lawsuits. Lawsuits affect people emotionally, affect the public emotionally. They get a lot of press. They may hit an insurance policy. But the flip side of that coin, and just as important, if not more so, are criminal prosecutions, where someone could be punished criminally or go to jail for their acts. And I think the prosecutors are equally as important, if not more so.
Okay. With the studies and the science showing that low VO2 Met scores cause a deficiency in the body's ability to release heat, meaning that people who do anything that requires high intensity effort, that combined with low Met scores, has a greater potential for heat storage even in a hydrated state. This is what the science and the studies, the position statements from the American College of Sports Medicine, the National Athletic Trainers position statement, clearly this information is abundant, that high intensity exercise in combination with low Met scores is the #1 cause of exertional heat stroke. That being said, who's going to be held responsible when this is brought out in a court of law? Is it going to be the coach, or is it going to be the athletic trainer? Is it going to be the school? Is it going to be the school board? All the people who are in leadership positions that can actually find out who's deficient, who's not. Just because it's not being done on a regular basis from the pro level to the college level to the high school level, who's going to be responsible? Is it going to be the coach, or will it be many other people in leadership positions that should have acted on this information?
And there's several questions there, and there's also the legal versus the practical of what happens. The law and the interpretation of law, whether it be in this state, I will talk about other states in that regard, I feel comfortable doing that, is usually slow to catch up with hard science and fact. Now, everything that you've said, and I have a list here of 13 things that I'm sure we'll go into later, every one of those scientifically is hard fact. Any cardiologist who's reputable will tell you that. Any sports physiologist, any PhD will tell you that. Any trainer who's worth his salt will tell you that. It's been there forever. Since I played football, since I was in track, since I rode crew in the 70s and the 80s, it's been there.
And that's a strong point. It has been there.
It's been there.
Been there.